Let me be precise about what you're about to hear. This isn't a story about politics. This is a story about federal court, about conditions of release, about arrogance, and about what happens when a defendant forgets that every single decision they make after an indictment is being watched. I've been around federal litigation for over 30 years. I've sat through thousands of bail hearings. Most of them are boring, procedural, predictable. This one wasn't. It was 9:12 in the morning when the courtroom deputy called the case, and the defendant stood up like he was about to accept an award. His name, at least for our purposes, was Nolan Pierce, 41 years old, founder of a data security company that raised money by promising enterprise-grade encryption tools to hospitals and banks. The kind of guy who wears a Navy suit that costs more than most people's rent and still somehow looks like he thinks the room is lucky to have him in it. He'd been indicted on 8 federal counts: wire fraud, conspiracy, money laundering, and this part matters, obstruction-related conduct that prosecutors were still actively building. The initial bond package had been generous. Home confinement, GPS, no new lines of credit, no contact with witnesses, surrender your passport, no encrypted messaging apps. And Nolan had agreed to all of it. He had smiled when he agreed, because people like Nolan always believe the system is a stage and they're the lead actor. They think compliance is something you perform for the camera. They think rules are suggestions for other people. At 9:14, the judge came out, not rushed, not emotional, calm, the kind of calm you only see from someone who has the power to change a person's life with a sentence. The government stood first, and the assistant U.S. attorney didn't start with drama. No speeches, no morality. She started with a timestamp. Your Honor, at 7:37 p.m. on Sunday evening, the defendant violated the no-contact condition of release by sending a message to a cooperating witness. 7:37. That's not an accident. Prosecutors don't lead with time unless they can prove it. The defense lawyer did what defense lawyers always do in the first 2 seconds of trouble. He turned his head just slightly toward his client. Not enough for most people to notice, but enough for anyone who's lived inside courtrooms to read it like a billboard. What did you do? Nolan's face didn't change. Not yet. He still looked confident. Still looked like he thought this was a misunderstanding that money could smooth over. The prosecutor continued. Your Honor, this message was sent through an application the defendant was specifically ordered not to use, an encrypted platform that automatically deletes conversations. He used it anyway. Then she paused, and I want you to understand why that pause matters. In federal court, pauses are weapons. They're not hesitation. They're setup. She looked down at her binder like she was about to read something routine, and then she said, the message reads, quote, do not screenshot. We need you consistent. Delete the ledger copy you kept. You're loyal, right? End quote. And that's when Nolan's posture changed. It wasn't a collapse. It wasn't theatrical. It was subtle. His shoulders tightened, like his body was trying to shrink away from his own words. Because here's the legal reality. You can't explain away a lot of things. You can spin a phone call. You can debate intent. You can argue misunderstanding. But you can't misunderstand. Do not screenshot. That phrase is a confession without a signature. The judge didn't react, not visibly. But the judge did something even more important. He asked one question. Counsel, he said to the defense attorney, is there any dispute that your client sent that message? And if you want to know what a case turning in real time looks like, it looks like what happened next. The defense attorney didn't answer right away. He glanced down. He adjusted his papers. He swallowed. 3 seconds. That's all it took. Because in court, 3 seconds of silence can sound like a siren. Then he said, Your Honor, we do not concede the context. Not the words, not the sending, not the account, just the context. Which is another way of saying, yes, he did it. We just want you to ignore what it means. The prosecutor didn't raise her voice. She didn't need to. Your Honor, she said. The cooperating witness immediately preserved the message by photographing it with a second device before it could delete. We have the image. We also have the service provider's server-side log showing the message was transmitted from the defendant's phone at 7:37 p.m., and we have GPS data placing the defendant at his residence at that time. Evidence, not speculation. Then she laid the second brick. Additionally, at 6:23 a.m., Monday morning, FBI agents executed a consent search of the cooperating witness's workspace and recovered a USB drive labeled Ledger Basket. The witness states the defendant demanded it be destroyed. Now we're no longer discussing a technical violation. Now we're discussing witness tampering behavior. obstruction behavior, consciousness of guilt, and the judge knows that. The defense attorney tried to recover. He started talking about stress, miscommunication, the defendant panicking after reading negative press. He used phrases like momentary lapse. He tried to reframe it as emotional. But federal judges don't run on vibes. They run on standards. The judge leaned forward slightly and asked, "Mr. Pierce, stand." Nolan stood. You could see the camera-ready confidence trying to come back. You could see him attempting to look composed, but his eyes kept flicking just for a fraction of a second toward the prosecutor's binder, because he knew there was more in there. And there was. The prosecutor didn't even ask permission this time. She simply said, "Your Honor, there is one more piece of information relevant to the bail conditions." She held up a single printed page. 1 hour after the message was sent, the defendant used a second phone line, an unreported line, to place a call to a number registered to the witness's sister. The call lasted 47 seconds. 47 seconds is long enough to deliver a threat, long enough to deliver a script, long enough to say, "You remember what you're supposed to say." And it's also long enough to destroy the defense's last safe argument. It was a one-time mistake. Because one-time mistakes don't come with backup phone lines. The judge set his pen down. That motion pen down is one of the most underrated sounds in a courtroom. It means the note-taking phase is over. Now it's decision time. "Counsel," the judge said, "the condition of release was explicit. No contact, no encrypted applications, no unreported lines. These were not ambiguous." Then he asked the question that ends bonds. What conditions, he said, would prevent this from happening again? And the defense attorney gave the answer you never want to give. He said, "Your Honor, we would propose stricter supervision. Propose, not guarantee, not assure, not explain how. Just propose." And in federal bail law, the question isn't whether you can propose something. The question is whether the court can reasonably find that any condition or combination of conditions will assure compliance and protect the integrity of the process. So the judge spoke slowly, and every word landed. "I find by clear and convincing evidence that the defendant violated conditions of release," he said. "I further find that the defendant is unlikely to abide by any conditions going forward." Then, the sentence that turns an out-on-bond defendant into an inmate in under 10 seconds. Bond is revoked. The defendant is remanded. Nolan's mouth opened slightly like he was about to object, but no sound came out. His lawyer tried, of course, he tried to ask for a stay. 2 days. 48 hours. Anything. The judge shook his head once. Minimal. Controlled. Denied. And then something happened that people don't understand until they see it in person. The marshals didn't rush. They didn't pounce. They stepped forward at a normal walking pace. One marshal moved behind Nolan, another to his side. And Nolan finally realized this wasn't a negotiation. His eyes widened. Not dramatically, just enough to expose the fear he'd been masking. He said, "Your Honor, I..." The judge cut him off without raising his voice. "Sir," he said, "you had your chance to follow the court's order." Then came the sound that the microphones always pick up, because it's sharp and metallic, and final. The cuffs. That click is the system telling you the talking phase is over. Nolan's knees didn't buckle, but his confidence did. You could see it drain out of him like someone pulled a plug. And here's why this matters beyond one man. A lot of people think bail violations are technical, like forgetting a meeting or being late. But in federal court, the conditions of release are the court's trust made tangible. When you violate them, especially with witness-related conduct, you're not breaking a rule. You're attacking the process. That's why the statute exists. Bail revocation exists because the court cannot run a fair trial if witnesses are pressured, evidence is destroyed, and defendants treat bond like a temporary inconvenience. And from a legal exposure standpoint, Nolan didn't just lose his freedom today. He likely increased his sentence tomorrow. Because obstruction, conduct, tampering, destruction, intimidation can change everything at sentencing. It can trigger enhancements. It can harden prosecutorial posture. It can turn a plea discussion into a superseding indictment. It can also destroy the one thing defendants rely on in white-collar cases, the judge believing they can be trusted to follow the law while the case moves forward. Trust is currency in federal court. Nolan spent it. And he spent it on a message that started with, "Do not screenshot." So let me ask you a question, because I genuinely want to hear how you read this. When a defendant violates bond by contacting a cooperating witness using an app the court banned and then tries to delete the evidence, was immediate remand the right call? Drop your thoughts in the comments. I read all of them. And if you want more breakdowns based on court procedure, legal standards, and what actually happens inside these rooms, subscribe, like, and share this story. Because in federal court, the law doesn't care how important you think you are. It only cares what you did and what you can prove.